Hello everyone, this is Vanshika Tainwala, legal intern under LEXIS and Company for the month of June. And today in this video, I will be talking about the topic laws relating to the beggary. So basically, startingly, I will be discussing about what beggary is. So basically, we all know that begging is an act wherein a person appeals to others for material help by words or gestures. It adopts several models for appealing to get alms. While some sing to attract attention, others display wounds, real or faked, yet some emphasis on their disabilities. So the problem of beggars has been since today, and nowadays people have started adopting beggary as their profession. So it is an immoral social evil. So bhiksha and danam in Hinduism, Jainism, Buddhism, and Zakat among Muslims are well known. It is a fact that beggars have their foundations in religious mendicancy, yet in the 21st century, it has socio-economic consequences that have made beggars a major communal problem. So the basic factors which are responsible for beggary are the economic causes such as poverty, landlessness, unemployment or underemployment, calamities, famines, and other conditions of disruptions. Second is the religious causes, which is relating to the religion and culture. Religious destitution is not tolerated by a large section of Hindus, Muslims, and Christian population, but even supported on religious grounds. Third is the social causes such as social disorganization, such as social change and industrialization have been responsible for beggary. So the disorganization of social institutions relating to lepers, lunatics, orphans, widows, divorces, infirm and aged, and other socially handicapped categories are because of lack of resources and uncertainty of the policy, and also because of the lack of loss of agricultural occupation, biological diseases such as sickness, infirmity, physical deformity, mental infirmity, old age. These all are also responsible for the concept of beggary. And natural calamities such as earthquake, floods, tsunami, hurricanes, and droughts imply that people leave their home and everything behind their places, homes, and they get damaged by their calamities. So now I will be talking about the constitutional aspect. So some provisions of the Indian Constitution have been challenged as it gives all citizens right to decent livelihood and right to protect their socio-economic rights. So rights are significant for a person's dignity, and poverty is a crucial ailment in our society that touches the issues of the human rights. So the United Nations organization, the UNO, was developed for promoting and protecting the human rights at the international level. So the Constitution of India guarantees all the citizens a right to life and personal liberty, which includes all factors of life, making a person's life worth making. So the interpretation of Article 21 of the Indian Constitution was extensively defined by the Supreme Court, and it was held that the right to life includes the right to live with human dignity. Also, in another case, the Supreme Court explicitly stated that the right to life under Article 21 also includes the right to livelihood, and Article 23 guarantees that this right to life is free from exploitation. Article 23 was integrated to stop beggary and other forms of human trafficking. Article 23, when we read it with Article 39 clause E and clause F of the Indian Constitution, that furnishes the directive principles of state policy, and it grants the persons protect and it grants to protect the persons from exploitation. So the anti-beggary laws can be called an obvious attack on the right to freedom of expression guaranteed under Article 19 clause 1 clause A of the Indian Constitution, and thus violates the right of life and personal liberty of the beggars as provided under Article 21 of the Indian Constitution. It violates Article 14, 20 and 22. The freedom of expression under Article 19 clause 1 clause A is the mother of all the liberties, and it is regarded as a lifeline for any democratic institution. So Sir John Stuart Mill, he rightly said that the right to silence the speech or expression of a person's opinion is like robbing the human race. So the word expression in Article 19(1)(a) has a broad meaning, and it is not restricted only to the expression, opinion or beliefs by words, writing, pictures. It can be expressed as an attempt to bring a meaning which can be the combination of the context or as well as the form. So the act does not differentiate between individuals and who are approved to request money and who are not. So this violates the right to equality under Article 14. Section 10 of the Bombay Prevention of Begging Act expresses that a handicapped detainee can be held in certified institutions for an indefinite amount of time after the detention period if it is ordered by the state government. So this is an infringement under Article 20, which protects the right to not be given a punishment greater than what is prescribed by law. Under the Act, individuals can be detained without a warrant and not be explained about the reason for their arrest. So this breaches the Article 22 of the Indian Constitution. So the begging laws have been mentioned under the Bombay Prevention of Begging Act 1859, wherein the term begging has been expressed. Also, there are a total of 20 states and 2 union territories that have adopted this Act of Prevention of Begging Act 1959 as a subordinate without any central act for the same reason. So this was the whole basic concept of begging and the provisions relating to it. And the police have also the powers to arrest the beggars, and there are some punishments for begging under the Bombay's Begging Act. It is up to 1 year to or 3 year. Hope you understood this concept. In the next video, I will be trying to cover out some landmark cases relating to the begging. I hope you understood this concept. Thank you for listening. Please like, share and subscribe our YouTube channel for more videos. Thank you.